Okay, we need to continue on with judiciary, and we have like just a bunch of vocab to do. So there's got 5 cards, and it's just like random vocab. Some of which, by the way, we've already talked about. So this is a little bit review. Funny thing is that that's judicial review, and so just have 5 cards ready. We're gonna fly through these, and then you're just gonna study them, and you'll know them, and that's good because you probably already know like more than half of them. All right, 2.59 judicial review, first one. We've already talked about this concept because we did Marbury versus Madison. Flip over backside. And one, it's the Supreme Court's power to declare acts of the legislature, executive, and states unconstitutional. Now, one thing I wanted to emphasize and why I have a card on this is because I expanded just what we've talked about. We already talked about judicial review, meaning that you can declare an act of Congress unconstitutional. But notice I also say an act of the executive, because we did talk about that when it came to executive orders that can be declared unconstitutional. And by the way, an act of a state could be declared unconstitutional. When we get to Unit 3, we'll be dealing with a bunch of different Supreme Court cases, 10 to be exact, and several of those are local laws or mandates or a school, rule, and those things will be ruled unconstitutional. So even a local government rule could be declared unconstitutional. Awesome. That's it for that card. Grab another one. All right, 2.60, stare decisis. Stare decisis. Obviously, another Latin phrase. We get into law, you get into a lot of Latin stuff. Although I always like, even though it's Latin, I think British, like, say stare decisis. All right, so decisis, by the way, means kind of like decision. And stare, kind of like stay, think stare, like stay the same, basically. All right, so backside, it literally means to stand by things that have been decided. Stand by things decided. The idea here is that as a court, you rule similar to cases that were ruled like in the past. So if there's other cases that were ruled in a certain way, then you rule like that. And that keeps the steady administration of laws, and that way it's predictable. So that's this thing. Idea that a legal case decision must be based on previous decisions. So you see the little chart, there's past, there's a case, here's the facts, and they make a judgment. And then current case, B, facts are similar to A, so therefore the judgment should be similar. That's the idea. An example of this, Plessy v. Ferguson, a very horrible case because it dealt with a group of African Americans who were suing because they were being forced to sit at a separate train car in Louisiana. And they sued that this is a violation of equal protection. And the Supreme Court ruled, no, that's okay. You can force people into a different train car as long as it's separate but equal. And that was stare decisis for 58 years. Like for 58 years, Supreme Court kept upholding segregated schools, segregated businesses, segregated, different things like this, transportation. And they ruled it over and over again, stare decisis for 58 years. But here's the deal. Stare decisis only has so much power. The Supreme Court can overrule itself. Of course, Congress could pass an amendment to overrule it. But the big thing is that the Supreme Court itself can overrule its stare decisis. So this separate but equal rule gets overturned in Brown versus Board of Education in 1954. And that's the process where, like, the 14th Amendment, the Equal Protection Clause of the 14th Amendment, which was specifically written to protect the rights of newly freed slaves, like, it's finally starting to be done. And it's been like 90 years, unfortunately. All right, so stare decisis means something, but it doesn't mean everything because the Supreme Court can overrule itself. Okay, precedents. 2.61. Precedents are very similar to stare decisis. So a precedent, get that down. Always, by the way, as we go through this quickly, pause if you need to. All right, it's some sort of principle or a rule that's been established in a previous legal case. So the precedent is Plessy v. Ferguson, and Brown versus Board overturned the precedent of Plessy v. Ferguson, thankfully. So Brown overturned Plessy. And the idea here as well is that all inferior courts must follow Supreme Court precedents. So Supreme Court rules about something on free speech, then or Second Amendment or whatever, then the states or all lower courts are supposed to follow that precedent. Sometimes, by the way, the Supreme Court's not very clear, and so it's hard to follow the precedent. The Supreme Court will have to rule again. Okay, that's it for that. We're going on to appellate. If you didn't finish that one, go back and finish the other one. All right, appellate 2.62. Already talked about this as well. Appellate. A-P-P-E-L-L-A-T-E, appellate. All right, here we go, backside. It means an appeals court. Remember, an appeal doesn't mean you have a trial again. It means that the facts are in the trial are looked at by the next court, by the appeals court. They just review the case. That's all they do is they review the case. They don't have a trial again. At the Supreme Court, you get 30 minutes to make your argument. Like the lawyers get 30 minutes each to make their argument. That's it. Sometimes they ask questions to them. It is not a trial court. The trial court is the lowest court. At the federal level, that's the district court. It is not a trial court. So appellate means an appeal, and you just review the case. And then they'll rule one way or the other. This is also a chance for other groups to get involved, usually interest groups, and they might send what's called an amicus curiae brief to the court. Amicus curiae, another Latin phrase. You might underline that. An amicus curiae is what's called a friend of the court case, friend of the court brief. And a brief just means like an argument. So like an interest group who's interested in gun, rights, Second Amendment rights or gun rights, they might send an amicus curiae to the Supreme Court on some sort of Second Amendment case, arguing why the Supreme Court should uphold the decision one way or the other. But a group that's not for gun rights, that wants to have more regulation of guns, they might send an amicus curiae to the court and argue why they should rule the other way. So amicus curiae are something that you see a lot at the Supreme Court or in during appeals sort of situations. All right, moving on to the next one. All right, and I think this is the last one. Writ of certiorari. So there we go again, another writ. Writ of certiorari, sometimes just known as cert. Sometimes just known as a cert. A writ of cert. Matter of fact, probably that's the best thing because most people don't walk around talking about certiorari all the time. But a writ of cert. And this is a really critical idea because this is how a case ends up at the Supreme Court. All right, flip over. It's also called a cert. Okay, did they grant cert? That's what they will say about the Supreme Court. Did the Supreme Court grant cert to your case? If it didn't, it's done. So it's a decision of an appellate court, in this case, the Supreme Court, to review a case. So if they grant cert, you're going to get a letter to the Supreme Court saying you're going to come argue your case in front of us. Remember, Supreme Court does not have to hear all cases. It's not possible. There's literally tens of thousands of cases. Over 10,000 cases are appealed to the Supreme Court every year. Think about that. Over 10,000 cases. They take less than 100. So they'll look through all these cases and they just deny most of them. In order for a case to be heard and be granted cert, we have what's called the rule of four. The rule of four. If 4 judges say yes, then a writ is granted. If 4 judges say yes, a writ is granted. Some people have asked me in the past, like, well, if the Supreme Court was expanded, like let's say FDR's court packing scheme happened and 5 Supreme Court justices were added or 6 Supreme Court justices were added, would the rule of 4 become the rule of 6 or 7? And the answer is probably yes. Otherwise, they'd have too many cases to look at and they wouldn't be able to make decisions. So rule of 4, writ of certiorari. Awesome. So just remember that. Writ of certiorari is the rule of 4. 4 say yes, then a writ is granted and your case is heard at the Supreme Court. Good job. That's 5 cards. Didn't take too long. Go ahead and study them. Thanks.